Death and taxes. Perhaps these are indeed the two great certainties in life. Both are inevitable, but the means of administering them bear debate. Law-abiding Canadians should not be figuratively taxed to death. They should not lose their businesses, their homes, and their physical health due to gross negligence by the tax collector. Although no one relishes the prospect of paying taxes, the vast majority of Canadians dutifully file their returns, keep their receipts, and claim only those deductions to which they are entitled. The Canada Revenue Agency, for its part, normally conducts its business fairly and efficiently. However, an egregious error by the Canada Revenue Agency can cost taxpayers dearly through no fault of their own. Sadly, such errors do occur from time to time. Motion M43 aims to correct this problem by instructing the House of Commons Standing Committee on Finance to study and report on the means of creating an enforceable duty of care from CRA toward Canadian taxpayers. The motion also aims to make CRA more accountable for its communication, to empower the Office of the Taxpayers Ombudsman, and to allow egregiously wronged Canadians to obtain remedies. Several stories illustrate the need for such reforms. Madam Speaker, Irv LaRue was an enterprising British Columbian. In the early 1990s, he cleared a patch of land to build a campground and recreational vehicle park. His troubles began when CRA audited him in 1996. CRA required certain paperwork which Mr. LaRue supplied. Through an egregious oversight, CRA first lost and then destroyed his original documents. However, this did not stop CRA from continuing to demand that he produce original documents, or from refusing to accept copies he painstakingly acquired and supplied. Instead, CRA continued to demand the originals that they had destroyed. They simply pressed on with their reassessment of his income, having destroyed the only evidence he could use in his defense. 10 years later, in 2006, CRA conceded that Mr. LaRue was correct all along and that he did not owe the taxes that they had originally demanded. However, the damage was done. The struggles with CRA cost Irv his business, his home, even his physical health. Mr. LaRue sued the CRA, and eventually the courts ruled that CRA owed him a duty of care and had acted negligently. His is a story of one man being ruined by egregious treatment by CRA. Madam Speaker, this should never happen again. Madam Speaker, in another case, a constituent of mine from Calgary Rocky Ridge named David was in a shared parenting arrangement with his ex-wife. In order to comply with the Divorce Act, he and his wife made an agreement that compelled each former spouse to pay support to the other based on their incomes. David did his best to comply with the law. He read the rules carefully and looked up information on CRA's website. He thought that he could rely on CRA's website for accurate tax information, especially since he found a seemingly helpful example on the website which matched his situation to a T. But some years later, CRA reassessed him, denied the deductions that his own website indicated he was entitled to, and demanded a very large amount of back tax. Mr. Speaker, clear and reliable communication from CRA to taxpayers would avoid much stress and cost to both tax-paying Canadians and to the Treasury. In a third example, Janet is a hard-working mom from Southern Ontario. She pays her taxes, keeps her receipts, and complies with the law. However, through no fault of her own, someone at CRA checked the box to mark her deceased. One click of the mouse caused months of trouble for this law-abiding taxpayer. CRA flagged her social insurance number, which stopped payments of her universal child care benefit. The CRA demanded reimbursement of an overpayment to her estate. They still accepted source deductions from her employer, presumably as a new category of working dead. Worst of all, her status as primary caregiver for her son was withdrawn. Despite repeated calls to Service Canada and CRA, her son remained without a legal caregiver. It's hard to imagine the stress and anguish of a mother facing the possibility of the state seizing her child and treating her like an abductor. Here is a woman who did nothing wrong, but suffered months of stress, financial uncertainty, unnecessary extra work, and fear of losing custody of her child due to an administrative mistake with far-reaching consequences. What would have happened had this occurred to a senior with reduced faculties who did not have an employer and a helpful member of Parliament in her corner like Janet did? How much suffering would ensue if someone's OAS, GIS, CPP, or other supports tied to their social insurance number suddenly ceased without notice? Madam Speaker, a more user-friendly resolution program with a stronger ombudsman could help reduce such strain on blameless taxpayers. These stories illustrate problems which Parliament can address through passing this motion. Indeed, I believe that it is our duty as an elected legislature to respond to injustices caused by Canada's tax collector. As members of Parliament, we must respond to developments in the law which come up through the courts. When a court, such as the Supreme Court of British Columbia in LaRue and Canada Revenue Agency, makes a new finding in federal law which could have widespread consequences, it's incumbent upon Parliament to respond. In paragraph 209 of the LaRue case, Justice Humphreys concluded that, in the circumstances of this case, the employees of CRA, more specifically the auditors, owed Mr. LaRue a duty of care. She went on to find in paragraph 311 that the standard of care owed to Mr. LaRue was that of a reasonably competent tax auditor in the circumstances. Madam Speaker, the precedent-following nature of Canada's common law means that courts throughout Canada will now treat this duty of care decision as persuasive or a binding precedent, depending on their level. If appeals take the matter to the Supreme Court of Canada, this duty of care may well become the law of the land without legislative input. M43 proposes that Parliament take up its responsibility, get ahead of the courts to study the best way to address the issue. The motion instructs the House of Commons Standing Committee on Finance to study and report on the steps necessary to create a legally enforceable duty of care owed by CRA to Canadians. In plain language, a duty of care means that someone must consider the legitimate interests of the other party in a particular relationship, so that the former takes care not unduly harm the latter. Whether we like it or not, all Canadians enter a relationship with CRA, an agency which is far more powerful than any individual or business. Such power may be necessary for a functioning tax system, but should include safeguards against abuse, such as a duty of care. By having the Finance Committee study and report on the matter, Parliament can ensure that we receive information needed to make a wise decision. We can hear from a wide range of stakeholders, from CRA itself to tax lawyers, taxpayer advocates, accountants, research staff at the Library of Parliament, and ordinary Canadians. Referring the matter to committee also ensures that the different parties can have their say for a measure which will affect Canadians regardless of political persuasion. By sending the matter to committee, Parliament ensures that the deliberations are visible to the public, thus contributing to the government's stated objective of open government. Madam Speaker, I recognize that the Finance Committee has many pressing matters to address in the coming months, so I've included a generous timeline for M43, instructing the committee to report back by the last sitting day of 2017 gives it a year and a half to address the matter without sacrificing other important priorities. Creating a duty of care between CRA and taxpaying Canadians is an important step. One which should be taken carefully and correctly, with the full participation of Parliament, but taken nonetheless. This brings me to the specific measures which M43 proposes and the reasons behind them. Madam Speaker, a duty of care is always accompanied by a standard of care by which it is measured. In the LaRue case, Justice Humphreys found the standard to be that of a reasonably competent auditor. But what guides reasonably competent auditors? What guides CRA as a whole, determining how to treat taxpayers? Madam Speaker, the Taxpayer Bill of Rights already provides a list of expectations for how CRA should conduct its affairs. However, the Taxpayer Bill of Rights remains more aspirational than enforceable. M43 seeks to remedy that by instructing the Finance Committee to study ways to make the rights contained in the Taxpayer Bill of Rights enforceable as the standard of care to which CRA will be held. The motion also contemplates expanding some of the rights contained in the Taxpayer Bill of Rights to address the problems which the stories of Irv LaRue, my constituent, David, and Janet from Southern Ontario faced. Adding the requirement that CRA take reasonable steps to avoid frivolous, vexatious, malicious, and/or grossly negligent actions toward taxpayers codifies something which CRA should be doing anyway, thus giving clarity both to CRA employees and to Canadian taxpayers. Adding the requirement that CRA provide accurate and reliable information addresses David's case. If someone consults CRA's website for information about claiming a deduction or credit, finds an example that matches his or her family's facts to a T, he or she should be able to count on the information being accurate. That brings me to the proposal to empower the Office of the Taxpayers Ombudsman to investigate, enforce, and dispense remedies. A stronger ombudsman with these powers would prevent many disputes from going to tax court and would act as an internal correction measure, balancing the needs to collect revenue efficiently and an obligation to not abuse taxpayers. Most importantly, it would provide a way to make taxpayers whole if the ombudsman finds gross negligence. A stronger ombudsman could help sort out smaller mistakes with large consequences, such as when Janet was incorrectly marked as deceased. It could also discourage CRA employees from digging in and standing by their errors when they make mistakes, since a smooth investigation and remedy system could deal with mistakes quickly and quietly. Mr. Speaker, rights always come with responsibilities, and this motion is no exception. In creating new rights or expanding the existing ones under the Taxpayer Bill of Rights, we in the legislature are responsible for imposing reasonable limits on them so that they do not cripple the CRA's ability to collect revenue. The motion includes an instruction to the Finance Committee to study the steps necessary to impose reasonable limits on the taxpayer rights so that Parliament can strike the right balance between collecting revenue and protecting Canadians. To be clear, this motion does not make CRA liable for every mistake made by its employees, but it does seek to hold CRA accountable for gross negligence. The Finance Committee is ideally suited to discuss these limits and consult with the Minister of National Revenue and representatives of her department on where to set them. CRA plays an essential role in financing the government and so should not be impeded except to the extent needed to protect taxpayers from egregious abuses. Mr. Speaker, let me conclude by appealing directly to my honourable colleagues in each party. Members of the government and other opposition parties may be asking why they should support a private member's motion about the Canada Revenue Agency. To my colleagues in the government, I would say that I support their campaign promise and the Minister of Revenue's mandate to take action to make CRA more fair, more helpful, easier to use, and more, as they put it, client-focused. This motion squarely fits with those laudable goals and offers a thoughtful way to implement them. Through this motion, it may be possible for my Conservative colleagues and me to help the government fulfill this particular plank from their election platform. We welcome the opportunity to work together to study the matter and draft a sensible solution which is good for all Canadians. To my colleagues on my left on these opposition benches, I would say that the measures proposed in this motion go to the heart of their party's historic desire to be Canada's social conscience and to make sure that ordinary Canadians get a fair shake. After all, this motion will be most beneficial to Canadians who cannot afford expensive professional tax advice when preparing their returns and cannot afford legal representation if they become part of a dispute. Regardless of whether a Canadian votes Conservative, Liberal, NDP, Bloc, or Green, we all have to pay taxes and we all want to be treated fairly by CRA. We can, and we do, disagree as parties on what the tax rates should be and how taxpayers' dollars should be spent, but surely we can all agree that the tax collector should be efficient without crushing Canadians. And when it comes to paying taxes and disputing a CRA ruling, the process should never be the punishment. And so, Madam Speaker, I urge all of my honourable colleagues to join me from all parties and vote in favour of motion M43. Thank you, Madam Speaker.